Hello, everyone. Welcome to Him's House. We have a very special episode today featuring patent attorney Gaston Kroub. But before we get into the episode, I'd like to acknowledge our flagship sponsor, Godel Terminal. People have tried to build a Bloomberg killer for years. I think Godel might actually pull it off. They're just getting started, but what they've already built delivers 90% of Bloomberg's functionality at less than 10% of the price. It's a full trading terminal for $80 a month. I use it daily to track short interest, institutional ownership, analyst ratings, and more. If you want access to the data powering Him's House, sign up today and get 25% off your first month. The link to sign up and get that deal is in the show notes below. Here is our conversation with Gaston Kroub. Him's House, episode 37. I'm Jonathan Stern. I'm here as always with Patrick Lester, who goes by the name Bayside in the Him's House Discord. Today we're joined by Gaston Kroub, patent attorney, above the law columnist, and one of the sharpest minds in all of pharma IP. Gaston's been practicing at the intersection of intellectual property and business strategy for over 2 decades. He's represented everyone from startups to global giants and has become one of the premier commentators on how litigation, regulation, and patent portfolios are shaping the future of healthcare. Now, as many of you know, a few months ago, Bayside published a special report for Him's House about the personalized compounding exemption, which in the time since has really become the definitive report explaining why Him's personalized approach to GLP-1s is legally viable. That piece touched briefly on IP at the end, but it was primarily about the FDA's regulatory framework that allows Hims to continue offering GLP-1s via 503A pharmacies. So, today's episode will be all about patents and what may come next for Hims and Novo Nordisk after Novo pulled out of the partnership last week, issued that scathing press release, and sent shares of Hims down 35%. Gaston Kroub, welcome to Hims House.
Thank you, Jonathan, and thank you, Patrick. Very excited to be here, especially after that warm introduction.
So before we dive into the Hims Novo legal situation, could you give listeners a quick overview of your background and how you became interested in the legal side of GLP-1s and compounding?
Sure. So I'm a registered patent attorney, which means that in addition to being licensed to practice in New York and New Jersey, where I'm a member of the state bars, I also, upon graduating law school, took the patent bar exam. And I'm licensed to practice in front of the United States Patent and Trademark Office. In the history of these United States, I'm patent attorney or agent number 51,903, which is a number that I will have until I hang up my stirrups. And actually, in one of the twists here, my first job at a big firm after law school, I was actually immediately put on a case involving Novo Nordisk. They were a client of the firm. It was a case against Teva with respect to recombinant human growth hormone and some patents that Novo had on that technology. Fantastic case. Actually went to trial in Delaware, I believe, if I remember correctly, in the summer of 2003. So we're going back over 20 years now. It was interesting to me almost 2 decades later to see Novo's name back in the news. Obviously, I don't represent them anymore. I don't have any contacts with the company, and everything I say is going to be based on publicly available information. But it was good to see a client name, right, in this space, especially as the GLP-1 market took off. Clearly Novo's experience in the diabetes market led to the development of the semaglutide, Ozempic, and Wegovy. It's been very interesting to follow both the FDA side of the cases as well as the IP side of the cases ever since.
Great. So I want to jump straight to our headline question. Will Novo Nordisk sue Hims? What do you think the odds are that Novo actually brings a patent suit against them?
So I think the odds are higher than they were last week. I know that's a little bit of a cop out answer, but the it is true that the risk level, at least in my opinion, for HIMS to get sued by Novo has gone up. I think the more salient part of the question, though, is will it be a patent case, or could this be another situation where Novo leans on the same types of arguments it's leaned on in over 100 cases that it's filed so far against compounders or pharmacies or medical clinics and weight spas, however you want to couch the defendants. And do they try to copy what Eli Lilly is currently doing against two large compounders in Strive and Empower? So I think the risk profile of a lawsuit by Novo against HIMS has gone up. I still think it's unlikely that they do so based on their patents, because I think they have more targeted and less risky ways of going after HIMS if they so choose. But I do think that in light of the fact that they try to develop a working relationship and it clearly has not worked out, that could mean that Novo will take efforts. In preparation for this podcast, actually, I took a look at another actually pretty similar situation that I had commented on, and that was when Elon Musk bought Twitter, right? And there was a lot of talk at the time. Will Elon Musk, now that he owns X, right? Will he go after Facebook for Threads, which was Facebook's, Twitter copycat type of service? And at that time, I wrote a column on Above the Law, 3 reasons why Elon Musk was not likely to go after Twitter. And I think some of this, not likely to go after Meta. And I think some of the same reasons apply now, right? Litigation is costly and disruptive. Nobody likes to lose. And particularly in the patent case, but even in some of these, false advertising / Lanham Act claims that Novo has brought against compounders, they have had some legal setbacks. Nobody likes to lose. And third, and this might be, the best explanation for where we are and where we continue to be if Novo never pulls the trigger, sometimes the threat of litigation is just as valuable for a company as actually pulling the trigger and filing a complaint. So, you asked about percentages. I still think we're likely to remain in that kind of, period where Novo has the ability to file a case at any time, but doesn't pull the trigger. But once they do, I think that would have means that they're prepared to, sign up for the multi-year campaign that litigation against HIMS would be. So
yeah, and we're going to talk a little bit about, if Novo were to file the lawsuit, how long would it be? What would it look like? The nuts and bolts of all of that. It sounds like you're saying less than 50%. Is that right, Gaston?
Yeah, that's still, unless and until I see something, more specific from Novo. I think the strongly worded press release that they put out actually lowers the risk that they file a lawsuit, because one of the ways that they could have really escalated would be to file a complaint and then have the press release say, hey, look, we filed this complaint. We've terminated all relationship. Here's all the bad things that HIMS has done. I think they took a little bit more of a measured path. And I think it's also consistent with Novo and by extension, Lilly's strategy as well around these GLP-1s. It's really, in my view, a multi-year controlled aggression approach that we're seeing them play out, where they went after some of the low-hanging fruit in terms of really policing people that were selling counterfeit Ozempic or counterfeit Mounjaro, whichever one you want. Then they, Lilly has kind of upped the ante a little bit by going after some of the larger compounders in Strive and Empower. Obviously, both companies were very involved in the compounder lawsuit against the FDA, which is, again, kind of an escalation, kind of sending a message that, hey, we're policing this market to the best that we can. And, at the same time, and this I think is really very important to remember, especially as we talk about Novo, Novo is already in the midst of a multi-year patent battle against generics that want to sell generic copies of Ozempic. So they don't have a clean slate within which to just like look at a company like Hims and say, what can we do to take down Hims that doesn't impact on any other aspect of their business? Everything they are doing and this controlled aggression approach seems to be trying to find the balance between making it clear to everyone that this is a market that they're policing and they're not scared to use legal tactics in order to advance their aims, but at the same time, keeping their eye on the main prize, which is how do we protect our monopoly on Ozempic for as long as possible.
Real quickly on the generics, could you give us a little background there? Who is filing the lawsuit against Novo, and how's that going?
So there's actually been a number of different lawsuits that have been filed, including one that was combined into what we call an MDL, or multi-district litigation. But generally, the way generic challenges work in this country is there's a branded drug that somebody's selling, a generic company or two or three decides, hey, we want to get a piece of that market, and they file what's called an ANDA, abbreviated new drug application, with the FDA. Now, under the Hatch-Waxman Act, which is the statute that governs these types of cases, the act of filing an ANDA by a generic puts the ball back into Novo's court. And Novo has, a certain period of time within which to file a patent infringement lawsuit based on the patents that they've listed in the Orange Book, which is the FDA's listing of patents that are relevant to branded drugs, to file against your generic and say, here's the patents that we think you're infringing, and that leads to the lawsuit. So constructively, the act of filing an ANDA by a generic is an act of patent infringement according to the statute, and that's what triggers Novo's ability to bring that defendant into federal court. Now, most ANDA cases are filed in the pharmaceutical hotbeds of New Jersey and Delaware, where a lot of the pharmaceutical companies, including the generics, are based. And, they follow a pretty typical multi-year path where the branded company is trying to prove that the patents in the Orange Book are going to be infringed by the proposed generic. And the generic company, for their side of the case, is usually trying to prove that the patents that are being asserted against it are invalid, right? That the patent office should never have allowed those patents to issue. The one thing that we don't have in a patent case involving a generic and a branded company is damages, because obviously this is all happening before the generic is actually allowed to market. That might not be the case, though, and this is something we're going to get back to, I'm sure, later on in the conversation. This whole question of damages is something that I think would be very relevant to a potential lawsuit between Novo and Hims, should that arise on the patent side down in the future. But to circle back, so we have we have a number of generic companies, some names that folks would know, that have, that decided to challenge Novo's patents, and to say, we want to be able to sell it. So probably I would say the name that some of your listeners may know is Mylan. I think they rebranded as Viatris or something like that. Mylan's a very active generic company. And they actually pursued a little bit more of an aggressive strategy against Novo. Not only did they file their ANDA and get sued by Novo and fight back in court, but Mylan has also filed what we call IPRs, or inter partes review, in the U.S. Patent Office against certain Novo patents. So this is all pretty typical behavior. These cases have been going on for some years. There was a whole number of settlements that were announced from the multi-district litigation, but now there's some other challengers that are in the mix. So, I think what's important for this audience, and especially when you're thinking about, what Novo's patents are currently doing, right, and how that might bear on whether Novo uses them against Hims, the fact that there's active litigation against generics means that Novo's patents are currently at risk, and any additional assertion by Novo of those patents will just up the risk, because now you're inviting a new target, in this case potentially Hims, to go out and challenge the patents both in court and potentially in the patent office. So, like I said, it's not as simple as Novo just being able to say, hey, no matter what's going on this side of the fence, that's not going to impact on Hims. When it comes to the patents, you only get one or two or three or however many are listed in the Orange Book, and we know that Novo has a lot that are listed in the Orange Book. But the ones that might be relevant to HIMSS is going to be a self-contained universe. And, every time you put any patent at risk, you're also asserting it, but you're giving the defendant a chance to knock that patent out for all time. And that's something that these companies have to really strongly consider before they pull the trigger on a lawsuit.
Great. I'll turn it over to Bayside with a few follow-up questions.
Okay. We got off to a roaring start, I think. And we got our headline answer. I'm going to spend a little time stepping a little bit backwards from what we just did. Not everyone, in fact, perhaps most people who are listening to this podcast are going to consider themselves up to speed on even the basics of patent law. I followed, I think, pretty much everything you just said, but nevertheless, I think it's worth stepping backwards and covering some of those basics. So let me just run through a few of these things. So for starters, you talked a lot about generics. I think we'll come back to that. I do know that later on in this interview, we're going to get into even some other things. You mentioned Strive and Empower, and maybe some similar things that are happening in Delaware that may be related. But let's go backwards and just sort of paint some of the basics. So Novo and Lilly, and I'm going to throw Lilly in here too, even though they're not necessarily directly related to HIMSS. A lot of their experience in each case is probably at least relevant in terms of what's been happening. Both have been involved in any number of lawsuits against compounders specifically over the past, few years. Can you talk a little bit about what's been happening there? I guess the very first question is, have any of them been on patent grounds, or more broadly on intellectual property, including trademarks, or even beyond that? What has been happening up until now, specifically with respect to compounders?
Yeah, that's a great question. And it's a good way to kind of refocus on what Novo's actually done so far. So unless something escaped my notice, I don't believe that Novo has ever used any of its patents against a compounder. All the patents that Novo has kind of put into play have been against generics, which we've addressed, and I'm sure we'll get back into down the road. So what kind of claims, and I did reference before that Novo has filed well over 100 of these types of cases. I believe cases have been filed in over 30 of the 50 states. So Novo's been very active with the non-patent IP claims against compounders. And what we've seen so far have been cases that kind of arise out of different aspects of IP. One you already alluded to, Patrick, which is the trademark infringement, right? So if you had a compounder that was particularly unskilled in marketing and said, we're selling Ozempic, right, when they're not, using the brand name, that's an act of trademark infringement. And there have been some examples of that. Those are the types of cases where you quickly see default judgments, meaning that there's no defense and they shut it down pretty quickly. But there are other, trademark type claims, such as references to the brand that may not be completely accurate. I would say the other kind of, main pillar upon which Novo's built this series of lawsuits tends to fall under the kind of false advertising, which is not necessarily considered a separate branch of IP law, right? We have kind of the four cardinal branches of IP, which are patents, trademarks, copyrights, and trade secrets. False advertising usually falls somewhere under the trademark side of the fence, but will often involve, in addition to federal Lanham Act claims, which is the federal trademark statute, unfair competition and false advertising claims that may arise out of the state laws. So these cases tend to be filed in federal court, but they can sometimes have a blend of both federal claims under trademark law as well as false advertising and / unfair competition claims that you'll see that sometimes arise out of the state statutes as well.
Regarding false, I just, as someone that's not an expert in IP law, what is a false advertisement?
So false advertising is, now this is something that's disputed, right? But generally the idea is that you cannot misrepresent the fact, right, in in advertising for your product. So a clear example of false advertising would be for a compounder to say that they have FDA approval for their compounded product, right? Which they are allowed to sell, but they haven't gone through the FDA new drug application process. So that's a misrepresentation of fact. Where the line gets a little bit more blurry, and blurry lines are what make lawyers rich and litigation so long and complicated in this country, is where the line between factual misrepresentation and expressions of what you would call opinion or puffery, right? That's the language that the courts will sometimes use, or the cases will use. So it's not necessarily false advertising for me to say that my compounded version of semaglutide is as effective as branded Ozempic, right? That's my opinion, right? Now, could there be a misrepresentation of fact? Yeah, if I cite to a study that didn't happen, right, or something in support that suggests to a customer in a misleading way that I did something that I didn't do, now we can have a nice fight about it. And that's kind of some of the examples that we've seen. In particular, Lilly is dealing with this in their case against Empower, where Empower is saying, you're accusing us of saying all these false things, but none of them are actually false. They're just either our opinion or, we properly cited to, the studies underlying our claims. So that in a nutshell is kind of where the battlegrounds are on false advertising claims, John.
All right. I want to check a few more boxes. These can be quick answers. I know we're focused primarily on patents, and you can punt on this one, but I wanted to ask a couple of really quick ones with respect to FDA law.
Sure.
And this one, some of these are just questions that we get over and over again, and they're going to be simple things that I think you'll just kind of knock it out of the park, but still, I think it's worth getting you on the record saying these for those who don't necessarily know these things. So, under FDA law, my understanding, correct me if I'm wrong, is that anything in the FDA side of things, the FDA has there is no private right of action. So only the FDA has enforcement authority with respect to that particular piece of the law. Is that correct or not? What is private right of action?
Yeah, so that is correct. Basically, the way I would explain it for a lay audience is to say, I can't force the government. I can't step in the shoes of the government to do something that is exclusively under the right of the government to take action is, right? So there's a distinction here. There is a concept that maybe some of the listeners are familiar, which is the idea of a whistleblower, right? Which is, I know that my neighbor, is running a illegal gambling scheme out of their basement, and they're not reporting, to the IRS their winnings, and they're, I see the Brinks truck every night, honking its horn and taking the money away. I could be what's called an IRS whistleblower under that circumstance, and I could let the file a lawsuit on behalf of the government as a relator of the government and say, I'm aware of this tax fraud, and then if the government's successful, I'll get a bounty for being a good citizen. But even in the whistleblower situation, I'm not the real plaintiff, so to speak, right? The cause of action, the right of taking legal action, is actually that of the government. I'm just helping them by pointing out something that they didn't already know. But here, what we would be talking about is Novo can't, sue the compounders under an FDA claim, right? Because that's the exclusive jurisdiction of the FDA to bring those claims. Now, what Novo could do is they could sue the FDA and say, hey, you're not policing the market properly. But that wouldn't be a lawsuit against the compounders. That would be a lawsuit against the FDA, trying to force the FDA to take action against the compounder. So there is a distinction there, but you're 100% correct. FDA claims are the exclusive right of the FDA to bring. And the best that a branded company like Novo could do under circumstances is complain that the government agency, in this case the FDA, is not doing their job and bring a lawsuit to make that happen.
And a really short, just for the audience again. So if we're talking about Novo directly suing Hims, it's most likely going to be along the lines you've already discussed, which is not FDA law. It is mostly intellectual property, IP related, or some of the other things that you mentioned, which you don't need to
Yeah,
go
yeah,
over again.
I would say that that's right. I think you know the patent. I'll give you just to bring it full circle. What is a patent, right? A patent is confers what we call negative rights. A patent is the right to exclude someone from using your invention without your permission. So that's a right as the patent owner that Novo has, right? So if Novo decides, hey, we want to take action against Hims or any of these other compounders under our patents, the patent itself is their ticket into federal court to do that. And each patent that they have gives them a separate legal right to assert patent infringement for each given patent. So that's kind of one track that Novo can take. The other is the path that they've already trodden, right? Which is to file these claims laying in trademark or false advertising against compounders. And that would also be rights that Novo as a company has, because it's Novo's trademarks on Ozempic and Wegovy. It's Novo's, the one that's going to be harmed if someone's falsely advertising that their product is as good as, what Novo is selling. So that's the difference between these private causes of action and a public case, which is where the FDA is operating on behalf of the federal government.
This one I'm going to throw out there. You don't need to answer it now, but we might want to come to it later on when we start discussing whether or not, what might happen if a lawsuit were to actually occur. But I think it's worth at some point talking a little bit about the discovery process and some of the risks that might be associated with that. So I'm going to throw that. Don't answer that one just yet, but at an appropriate time, it'd be good to kind of work that in. Right now, I'm just going to shift to something you mentioned, which was the 30 odd patents. You may actually know off the top of your head exactly the number of patents that Novo has between Wegovy and Ozempic. But give a little bit of a sense of what are those patents on, for instance, on the molecule, on the drug dispensing device, that the injector pens that they're using, on methods and uses. Are some of these more relevant than others? Give us a really quick lay of the land. And by the way, I should say I tweeted something about this in the last few days, so I want your opinion because it's more important than mine. My sense is that of all these patents, the 343 patent is kind of the crown jewel, but I'm going to let you tell us about that patent landscape.
All right. So happy to do so. As a matter of first principles, I think it's important to understand that a branded pharmaceutical company like Novo has a fiduciary duty to its shareholders to protect its drugs with as expansive a patent portfolio as possible, right? Which means working with good law firms that know how to file patent applications, having a robust internal staff. And what you see, and we've seen increasingly over the years, is that when there is a blockbuster drug, there is a real pressure on the company to protect it with as broad and as deep a patent portfolio as they can. Or sometimes it's so broad and deep that it gets criticized as what we call a patent thicket, right? Just like this idea that you're, like around Humira, that there's over 100 patents that apply, and if they sue you, they're gonna hit you with 47 patents in a lawsuit. So what Novo has done here around Ozempic and by extension Wegovy is really try to stick to kind of basic good patent practice for a branded pharmaceutical company. And what that means is that they've gotten a lot of patents, right? They're not resting their laurels on any given patent, but you try to get as many patents as you can. And they've also aimed for diversification across the different types of patents. Now, when it comes to pharmaceuticals, the strongest patent that you could have is what we would call a compound patent. That means your scientists were working in the lab one day and they mixed together two things that, they didn't expect would work together. And then they found out that it, cured something. They made that discovery, right? Compound patents, you invented a new molecule that didn't exist before. That's not really what happened here, but Novo does have a number of compound patents on versions of semaglutide, formulations of semaglutide. And those are obviously very important pieces of the puzzle. The 343 patent that you mentioned is particularly important to Novo. And we know this because it is a compound patent. And we also know that Novo elected to have patent term extension apply to that particular patent. So a little bit of a digression, if you would, into what patent term extension is. Patent term extension means that if I have a patent covering a drug or a series of patents covering a drug, and as part of the normal FDA regulatory approval process, the FDA, just like the DMV and all other government agencies, took longer than they were supposed to. I could argue that my compound patent deserves, or any patent that I have, deserves extra protection, right? Based on the delay, right? Because we know this is the best type of patent. So most companies, when they're in the fortunate position of having a compound patent, they will pick one of those patents and say, we want the extension to apply to this one. And that's exactly what Novo did with the 343 patent. So instead of the 343 patent expiring right around sometime this year, they were able to get that patent extended out for a period of, I think, up to 5 years. And what that means is that they now have, I think it goes out to 2031. So what they now have is they have a patent that is kind of a super patent in the sense that it was supposed to die, but it got a transplant in the form of patent term extension, and now it's got a few more years to live. And that's great for Novo because it's in the category of a stronger compound patent. So that means it could effectively block not only generic versions of Ozempic, but also Wegovy. And the reason that is because when it came to the Orange Book listings for Ozempic, Novo included a lot of injector type patents, right? Patents on the mechanism of injection. And that got called out, and that's part of a broader issue in the in the legal community around these drugs, where there's been pushback by the FTC on companies listing non-drug patents to protect their drugs. And this was a critical thing that companies used to get away with. They would have the inhaler patents and all kinds of things that they would stick in the Orange Book. But there's been a crackdown on that. So when you look at the Orange Book listing for Ozempic, there were and are still a lot of injection device patents that are listed. But there are also some formulation patent, compound patent, including the 343, and then there's some method of treatment patents. So really kind of a smorgasbord, if you would, of different types of patents that they claim protect Ozempic. If you look, though, at the Wegovy Orange Book listing, there are no of these injector patents listed. What you have is a couple of compound patents, including the 343, different formulation patents, and then a couple of patents directed at what we call method of treatment, meaning using the active drug to help, in this case, people lose weight, right? So the idea is for a company like Novo, get as many different patents as you can across as many different inventive areas as you can, list them in the Orange Book, and just try to create as many roadblocks as you can for generics to be able to enter the market.
My quick understanding, and I'm going to turn it back to Jonathan in a second. And I should say, I think we had some questions here about generics, but I think we're going to punt on those. You already touched on it to some extent, but we're going to touch on Strive, Empower, and Sun Pharma a little later. But just to wrap this up before I pass it back to Jonathan, tell me if I'm wrong about this, and don't hesitate to call me out, because I don't mind I'd rather be accurate than not. My understanding is those device patents, as you said, the FTC called them out for listing those in the Orange Book, which I don't know necessarily if that renders them less effective with respect to any lawsuits with respect to HIMSS. But as far as I know, HIMSS is not doing anything with respect to those devices anyway. And then second, there was at least one other patent that was that got a bad IPR review during the generics back and forth, which led to a settlement. Then you've got this 343. You've got another one that was filed around the same time as 343, but actually rolls off early next year. And then on the Wegovy side, although those patents, I'm not sure if they're stronger or not, I haven't looked at them, but once Ozempic rolls off patent, then doctors can go ahead and prescribe that, for off use,
Off-label use.
off-label use. So in some ways, it's the Ozempic stuff that really matters because it's more relevant. If you have any quibbles or if I got anything outright wrong, let me know. Is that a decent description overview of kind of where all those various patents stand?
Yeah, let me try to tie it all together. What we've seen, right, both by the FTC action and by Mylan's success against at least one of the Ozempic patents, is that Novo's patent portfolio, while well put together, right, is not bulletproof. And I think that's what everybody has to remember, right? These things are not bulletproof. It is, and we're not even I'm not even talking about what it takes to win a patent case and how long it takes and all
We'll
the
get to
different
that.
differences that we'll get to that, right? But right, as we sit here today on June 30th, 2025, we already have some indications that Novo itself has gotten pushback in terms of its patent approach. And I think that is just important to keep in mind. Now, the other point that you made that's worth touching on as well is, what, if anything, is the applicability of those injector patents that may or may not have been improperly listed in the Orange Book against Hims. Mm-hmm. And the reality is, they're probably not that relevant. I haven't seen anything to suggest that any of them are. And that even if they were, one of the problems you generally have, and this has less to do with branded pharma and more to do with just patents on medical devices like inhalers and physical things, injections and things like that, is it's very easy to design around, right? You can get a patent on a very specific type of syringe. There's alternatives in the market that you could easily go to. So I know medical device companies love to fight about these things, and those cases can extend for a very long time. But the reality is, I think the real threat, if any, from Novo's patents against a company like Hims doesn't sit with Novo's patents on the injectors. If it's anything, it would be with respect to a patent like a 343. And the question would then be, could Novo meet its burden and Rule 11 obligation, right, which is the obligation on the company and its attorneys to only file cases in good faith, basically, to prove that a company like Hims, what they're offering actually infringes on the 343 patent, as an example.
All right, I'm going to turn it over to Jonathan. My big takeaway, the simple version of what you just said, is Novo's patents are not bulletproof.
Nobody's are. Nobody's are, and that's a very important thing for people to remember about patents. And if anybody needs any proof, the overwhelming majority of patent cases resolve in settlement, which means that, like a lot of other things, I like to talk about emotion in these IP cases, right? And there's some serious emotions that go with where the innovators, where the ones that created something, where the inventors, and then on the other side, while you're trying to claim something that you don't have. But eventually, if you look across, no matter what technology area, no matter how big or small a case, the overwhelming majority of patent cases eventually settle, which tells you that patents are not the greatest tool if you want to get a knockout blow.
All right, Jonathan.
Yeah, thank you for giving a full overview on what the crown jewel is and why, and the difference between molecule patents and injector patents and all of that. As we've floated, I want to talk about what a patent case looks like and what specifically it might look like if Novo were to sue Hims. So let's say that Novo does file a lawsuit against Hims, whether on patent grounds or trademark grounds or false advertising grounds or patient safety grounds or anything. Quick question is, would Hims have to stop compounding for the duration of that suit?
The answer is no, unless Novo was successful in getting a preliminary injunction, which is a lot more of an involved process and a lot more of an unlikely process than the ability to file a lawsuit, right? So in terms of a lawsuit getting filed, you put together a complaint. The complaint will list your causes of action. Why is company A suing company B? What are the grounds for that lawsuit? And that, in the normal case, if there's no preliminary injunction motion filed as a companion, the normal case would go along the track, and Patrick already referenced discovery, and we could talk about that in more detail. But there's a definite kind of series of steps that take place over a period of years to get from the filing of a complaint to trial, right? When you file a preliminary injunction, you're asking the court to intervene at an earlier stage of the process. And one of the things that we would want to see immediately, if Novo were ever to sue HIMSS on any of these causes of action, on patents, on false advertising, on whatever they want to do, are they also going to move for a preliminary injunction as well? And that will, that's also risky for a company, right? Because I talked about some of the reasons why companies don't like to file lawsuits, and one of them is you don't like to lose. Well, preliminary injunctions are very uncertain. And guess what happens when you file a lawsuit and you accompany it with a preliminary injunction? That case gets a lot more attention right off the bat. And then if you're unsuccessful in your preliminary injunction, public perception as to the strength of your case goes way down, even though the factors that go into deciding a preliminary injunction motion are not the same as, what you're going to be deciding at trial 2 or 3 years down the road. So, whatever they do, if and when they do it, the process of analysis from the legal community, and this doesn't always translate so well into the investor or media or even the media, right? But the level of analysis that we would do on the legal side would be, all right, what claims is Novo bringing, right? So if it was a patent case, which specific patents has Novo chosen to assert against HIMSS, right? Then you would also look at, if they're making a false advertising claim, what statements are they pointing to that HIMSS has made that they're complaining about? Or trademark, likely the same thing. Where do they believe that HIMSS is violating the Lanham Act? And then you would analyze whether or not those are things that HIMSS can actually control, or HIMSS might choose to fight back on, or HIMSS could just stop doing voluntarily and completely undercut the basis of Novo's claims, right? So there's a lot of variability. The only thing that Novo controls, though, is what goes into the complaint and the timing of it. And that's very powerful. And one of my arguments is that's so powerful that sometimes it's even better than filing the case. Just having that threat out there and that uncertainty out there is just as valuable for a company as Novo as actually filing the case. Because what happens is when you actually file the case, you've anteed up and everybody could see what your ante is. And that just makes you a little bit of a static target, and people could start poking holes in, well, that statement isn't really false, or they're stretching themselves to make this allegation, or this patent doesn't look so strong, right? So there's going to be a lot of give and take once a case is filed. But what Novo has in its back pocket right now is the decision whether to file, when to file, and what to file on.
Got it. So just to play that back to you, Novo would file the lawsuit against HIMSS. Then they would get in touch with the court and say, we want to file a preliminary injunction.
It sounds like they're not going to do it.
And the court would then rule.
Well, the court would then set what we would call a briefing process, right? So Novo would put in their arguments why there should be a preliminary injunction. HIMSS would have the opportunity to respond, using the preliminary injunction factors, which are, irreparable harm and public interest, right? There's things that have to have, and likelihood of success, right? You can't just get a preliminary injunction because you asked for it. You actually have to show that you're likely to win the case, which is not so easy to do, particularly on a very limited record. So most cases don't have a preliminary injunction motion accompanying. But regardless, no matter what happens in court, whatever Novo does in court, preliminary injunction, no preliminary injunction, HIMSS is going to have the opportunity to respond, right, in court at some point in the process and really throughout the process. The one thing that I want to remind everybody of, and the reason why Novo might hesitate to pull the trigger on a patent case in particular, is that by filing a patent case against HIMSS, that is an invitation not only for HIMSS to respond in that case against the patents on the question of validity, but also to go to the Patent and Trademark Office and argue that that patent should be invalidated or that series of patents should be invalidated. So it actually would open up the potential for a multi-front war against Novo's assets. And guess what? You only have to pop those balloons once and they go down. So there's nothing that Novo does is going to go unresponded to. And each step that they take is going to introduce at least some element of risk on a going forward basis.
Patrick, back to you. A little more context, and then we do want to talk about what possible outcomes of any possible lawsuit would
The
be.
outcomes, we definitely want to leave time for that, and then potential next steps after that. So we only have a limited time for these, what probably could be hour-long discussions by themselves. You mentioned a few cases that are kind of out there that are relevant. I think some of them are involving Lilly rather than Novo, but I'll let you give the details. One is Strive Pharmacy, Empower Pharmacy, and there's this other one that's in Delaware. Tell us a little bit about those cases and why they are relevant, and then we'll have one other set of questions about how Novo can push back, although you may have just answered that one. But let's start with these other cases quickly about why they're relevant.
Okay, so as a lot of the listeners will remember, really the beginning, the end of last year and the beginning of this year, where all the air in the room was taken up by the FDA shortage decision and the lawsuits that the compounders filed in Texas, trying to get the FDA to reverse that decision, to call into question the bases of the FDA's decision. Unfortunately for the compounders, those cases did not go well, right? The judge in Texas was not receptive to the arguments that the FDA was wrong to declare the shortage order. I think the thing that he clearly couldn't get around was the idea that if the FDA was right to declare the shortage in the first place, who am I to say that they were wrong to declare the shortage over, right? Like in his mind, those two questions were connected. Either the FDA knows what it's doing or it doesn't know what it's doing. And if it doesn't know what it's doing, then it was wrong. It may have been wrong to declare the shortage in the first place. So compounders, you lose either way. Well, that case is on appeal. But once it became very clear to everybody that the compounders were going to lose, at least at the trial court level in those cases, Lilly did something which I think is very interesting. And they filed two lawsuits. Both were filed on April Fool's Day. One was filed in Delaware. The other was filed in New Jersey. And they went after two, what I would consider larger compounders. One, a pharmacy called Strive Pharmacy, and the other called Empower. Now, thankfully, I don't have much need for medication personally, so I had never heard of either of these companies. But what was very clear was when I looked at the complaint that these were companies that are operating on a national scale, very different in scope than some weight loss clinic in Boca Raton that Lilly had shut down prior, right? So this was kind of a, as I called it, a little bit of an escalation and maybe even a series of test cases by Lilly, which I know Novo is watching very closely as well, to see, can we sustain these types of false advertising and trademark infringement claims on a national scale against people operating on a national level. So those cases were recently filed. And in both of those cases, the compounders have fought back, even though we're very early on in the process. In the Strive case, what Strive said is they filed a motion to dismiss, and they said, you can't sue us in Delaware. Delaware is not, we barely do any business in Delaware. This case doesn't belong in Delaware. We want the case effectively moved to where we're headquartered, which I believe is in Arizona. So their way of fighting back, at least as the initial response, is you went after us in the wrong jurisdiction. We want out. Okay, fine. Empower also filed a motion to dismiss in their case in New Jersey, but they went a little bit harder back. And what they say is they filed their motion to dismiss and said, you have failed to state an actionable claim against us. And what they're challenging is Lilly's ability to file this type of case in the first place. So they're challenging the fact that Lilly is attacking their statements about the safety of their compounded tirzepatide that they're selling. They're challenging the fact that Lilly is arguing that Empower isn't actually personalizing the doses for its patients. And they're also challenging the fact that Empower statements are about compliance with the FDA are, legal and not false advertising. Basically, what they're positioning that case to be is you can't use these types of claims to shut down lawful compounding. And that's the way they're positioning the case. They're saying, Lilly, you're upset about the fact that we're allowed to compound, and you're just grasping at straws to bring these very thin claims against us legally, and we're going to push back. So for this audience, for HIMSS, for everybody that's interested in this space, of the two cases that are worth a deeper look on an ongoing basis, the Empower claims and the response to those claims, I think, are going to be critical to monitor, because what they're really trying to do is undercut this whole idea that compounding is somehow illegitimate and that a branded company like Lilly can go after a GLP-1 compounder using these types of false advertising claims. So one to watch for sure. And I wish I would be able to tell you that this is going to be, decided relatively quickly. So far, that is not true. We have yet to see even Lilly's response to the motion to dismiss, and it's unclear to me, based on the docket, how long this could take. Based on my experience litigating in the District of New Jersey, where this case could be, it might be the end of the year before we get a decision on this motion. And all this motion is going to do is either have the case dismissed and set it up for an appeal if Empower wins, or if Lilly wins and some of these cases survive, then the case is going to go forward in discovery on those claims, and then we'll get a trial sometime in 2028, 2029. So these are not quick fix solutions for the branded company. And I think in the case of Empower, and also to some extent Strive, it's very obvious that even very early on in the case, the compounders have arguments that they could raise to either try to delay or, get an early win in response to the cases filed against them.
All right. I'm watching the clock on this because I want to get it back to the outcomes.
Sure.
Do you have a really quick answer on what's going on with Sun Pharma, if it's relevant?
Yeah, so that's just another patent case against a generic, and it's not going to get decided anytime soon. So that's the quick answer. As the
right.
Great. And just real quickly on the Empower case,
Sure.
if we get past the motion to dismiss, you're saying 3-4 years till there's an outcome.
Potentially, yeah. Based on trial schedules that I've seen, there. Put it this way, there hasn't even been a schedule entered in the case, so that is going to take time. New Jersey is one of the slower dockets that's out there, but again, Lilly knew that when they filed, and I think one of the reasons why, when you have when you're filing a case where the main value to you is a deterrent effect and you want to send a message, right? Kind of a marketing piece. You don't care to file in a slow jurisdiction. Actually, you want to file in a slow jurisdiction because that takes away one of the reasons that I mentioned really early on in the podcast, why you wouldn't file a case, which is you don't want to lose. Well, one of the ways to prevent losing is to make it that if I'm going to lose, it's going to be years down the road when everybody already forgets about it. But I get the immediate impact of getting the case on file. So I think it was a considered decision by Lilly.
All right, I'm going to turn this back to Jonathan, but the one question I had, which I'm going to let you incorporate as you see fit into Jonathan's question, was we did touch on some of the things that that HIMSS can do if it is in fact sued.
Mm-hmm.
If there's anything you've missed, you can be welcome to mention those, but I'll let you do that within the answers that you give to Jonathan about outcomes. So Jonathan, send it over to you.
Yeah, let's move to outcomes. I'm just looking at notes here, and we also want to talk about the future of compounding. So we let's if possible, move through the outcomes relatively quickly. If there's a lawsuit on IP grounds, question is, who do you think is going to win, Novo or Hims?
So the way I look at this is that Novo wins by filing automatically, right? Because it's going to have an impact on Hims. But the ultimate legal outcome is more likely to be one where Hims is able to continue doing what they're doing. And I also think that is going to, one thing that we haven't mentioned that is very relevant to this is a big part of Novo's decision whether to go after Hims is going to be tied to how well Hims continues to do selling compounded semaglutide in the market. So if Hims's compounded semaglutide business is very successful, that raises the chance of getting sued, but it also means that Hims will be more motivated to fight back. And over the full life cycle of a case, I would say that the advantage would be to Hims to come to an outcome that would be successful. Whether that's 3 years down the road, 4 years down the road, or longer, that depends on the case that gets filed. But short-term win, Novo for getting the case on file, getting a hit. Longer term, though, I think these cases are very difficult to win. And Hims, if they have the ability to outlast, should be able to persevere and ultimately get have the better of the situation.
And that would happen by way of settlement or by a judge actually ruling in Hims' favor?
It really all depends on how well the parties handle their new relationship of being in litigation against each other. We've seen what happens when they've tried to partner with each other. So it's not very exciting, but just like when you have a couple that's divorced and they have kids and they got to figure out a new way to get together and deal with the kids, we're the same. It's the same. It's exactly the same thing. I do my volunteer work in family law, and people always don't understand why. And I'm like, no, it's exactly like these IP cases. It's just it's just a different sets of circumstances, but it's all about the relationship. So settlement is always the most likely outcome, but how long it takes to get there is usually the biggest piece of the question.
I heard something really interesting, which is that whether it's settlement or Hims winning, you expect Hims to be able to continue doing what they're doing, which is selling compounded semaglutide. Did I hear that correctly?
Yeah, because I think at bottom, even though this is a little bit of a unique situation where you have a blockbuster set of drugs, and that's putting pressure on the compounding system. The reasons behind compounding and why we want to have it and why we want it to continue are still there, right? And I understand that there's a tension, but I don't think no matter what Lilly or Novo do, they're going to be able to get the law changed to completely ban compounding or completely ban compounding even for these GLP-1s. The question is scope and, maybe around the margins, are there certain types of sales that are going to be more acceptable than others? But it's like anything else in life. You could be the big bully and be aggressive, and that's going to get you just so far. But if once there's a fight in the schoolyard and the kid that's getting bullied fights back, they're usually able to, score some punches on their own. And I don't think any of these situations are going to lead to the death of compounding as a legal mechanism for pharmacies.
Okay, great. So if we could just handicap a likely settlement outcome, what do you think it looks like? What does Hims get? What does Novo get?
So I think what Novo would want would be to cabin the types of sales that Hims can make as much as it can, right? Now, this is presuming that Hims is continuing to run a blockbuster compounding business on semaglutide. I think Novo would be content with knowing Hims being limited to doing certain things that are prescribed and Novo could live with, as long as Hims is paying them something for those, for those sales. That would be an outcome that I think if we all got everybody together in a room today, reasonable minds could probably agree on. The problem is that Novo is not looking at this situation as just Hims, right? They're looking at this in the context of their fight against the generics. They're looking at this in the context of their fight against illegitimate compounding and counterfeit, right? It's all part of a broader story. So I think if it's worthwhile for Hims to continue to do it, it'll probably be worthwhile for Hims to pay some money to Novo, if Novo would accept it, to find an agreed upon space within which Hims can operate.
Okay, that's big. Jonathan.
Yeah, that's very big. Okay, future of compounding. There's growing concern, Gaston, I'm sure you've heard arguments around this, that companies like Hims, even if they are not violating the letter of the law, are taking advantage of a legal gray area using the personalized compounding exemption at national scale in a way that arguably undermines the incentives the patent system was designed to protect. What do you make of the framing there? And is this compounding exemption an unintended loophole that Congress didn't want and perhaps did not anticipate?
So I don't really care about the framing, quite honestly, because it all depends on your perspective. What I think is important to keep in mind is, if these drugs weren't this successful, weren't these important, weren't these really culture shifting, right? That there wouldn't be any tension with compounding. There have been a lot of other very popular drugs that's made a lot of money, and that didn't lead to, calls to unravel the whole compounding system that Congress put into place. So from my perspective, it's really, I don't think talk about loopholes or anything like that is what's important. I think what's important is to acknowledge that we're in a little bit of uncharted waters. We have companies with, quite frankly, unlimited resources at this point that are creating a narrative that they're getting hurt by these compounders, that are probably upset about the traction that the compounders were able to achieve during the shortage period, and are now trying to, in this, new uncertain period of time, throw their weight around, right, to try to argue that somehow the compounders like Hims and Empower and Strive and Roe are, taking advantage of a loophole that never was intended to exist. But it is in the statute, right? And I don't think it's going anywhere absent congressional action. So we really get to the point of, you could complain all you want, and you could use these, what I would call, blunt legal tools to try to create a deterrent effect. But if you're really unhappy with the law, you got to get the law changed. And, how long does that take? I don't know. Is it possible to get the law changed? I don't know. But I think, when we think about the framing of this dispute, it really is tied to the fact that we're in a period of uncertainty post FDA shortage. I haven't seen any good, I don't think anybody knows, honestly, just what the future is for Novo with sales of Ozempic and Wegovy, what the future is for Hims with the sales of compounded semaglutide. And these are and everybody's positioning themselves in a way where the big gorillas in the space, Novo and Lilly, are going to try to deter competition using every legal mechanism that's available to them. And to the extent that it's worth it for a company like Hims to fight back, I fully expect that they're going to do it. And everybody's going to spend a lot of money on lawyers, and everybody's going to hire great lawyers on all sides. And the law is going to develop because of the tension created by super duper blockbuster drugs and compounding that's allowed, but maybe wasn't ever thought of applying to drugs that are operating at that scale. So that's my framing.
Yeah, that's really helpful. I think it's worth throwing in that it is not Hims' responsibility either to change the law or not to take advantage of the law as it is. That's number one. Number two, And this is going to be very quick because there's just a tremendous amount of complaining. I think it's complaining online about the fact that Hims is violating the spirit of the law or what the law intended. Just real quickly, a judge is not going to rule against Hims because they're violating what the law intended or the spirit of the law. Is that right, Guest? Are there any cases
no, I
that
think in order for Novo or anybody else to be successful in a legal claim, they have to point to actual violations of the law.
of the letter
Right.
of the law? Yeah.
Right. If it's false advertising, right? Are you misrepresenting facts and advertising your compounded semaglutide? You either are or you aren't, right? And like I said, there might be gray areas around or areas of dispute around whether something should be characterized as a fact or an opinion. But that's not a debate over what the spirit of the law should be or whether or not compounding is legitimate at the root, right? That is not what the job of a judge is. The job of a judge is to look at the law, interpret it to the best of their ability. And quite frankly, under our federal court system that's been in place in this country for well over 200 years, the job of each court is to prepare the case for a decision by the court above it, right? The job of the judge in New Jersey is to prepare the case as best as he can for review by the Third Circuit Court of Appeals, which handles all appeals. And then if it's a case of importance that deserves the Supreme Court's attention, the appeals court's job is to prepare the case for Supreme Court review. We have a system of law, and I would fully expect that all decisions that are made in these cases on a going forward basis are going to be based on each court's interpretation of the law as it is, and not the court substituting their judgment for what the law should be.
Excellent. Over to you, Bayside.
Okay, I guess we're wrapping this up with looking ahead in terms of congressional action. I'm going to go ahead and outline some things that, at least as I perceive them as a lobbyist in the HHS space. But I will invite you to contradict me if I'm wrong on anything, or if you have anything to add. I would love to hear what it is. First, I'm going to start by building off the topic we just had. People spend a lot of time making essentially the argument about, does it make sense that compounders should be able to mass compound at scale a patented drug? Do you really think that that's what Congress intended? And because it's reasonable to make the argument that compounders able to make compounded versions of patented drugs could undermine the profit motive for big pharma, that was not what Congress intended. Therefore, we should assume that either the FDA will take action and or there'll be some adverse impact in terms of patents. We've been addressing that throughout this entire discussion. But I want to add a few additional things which you can certainly react to. There is a history here, and I mentioned this in a tweet over the weekend, that I think people have been ignoring, which is that if we go back to the late 90s, there are a bunch of new laws and regs enacted. I think it was 97 around compounding. A few years later, there was a lawsuit which ended up going to the Supreme Court. And that lawsuit centered around, at least in terms of the decision, around the primary thing that Congress had focused on as a way to limit compounding of these drugs, which was they basically said, okay, we really need to strike this balance between the compounders who've been around for a really long time and big pharma. The way we're going to limit this is we're going to allow compounders to do compounding, but we're not going to let them market it. We're not going to let them advertise it. Well, in 2002, we had a Supreme Court decision, Thompson v. Western States Medical Center, which essentially threw out that mechanism for essentially limiting the marketing of compounded drugs on free speech grounds with respect to commercial speech. Supreme Court said to Congress, listen, commercial speech is not as protected as individual speech. There are some rules and check marks that you have to do to justify that kind of a limitation. But government had not done this. The Congress had not done this. So they essentially threw out on constitutional grounds that aspect, the primary way that Congress had intended to avoid the problem that we have today. Fast forward from there about another 10 years, there was a significant compounding law enacted. They essentially reinstated some things that's also struck out in some of that earlier legal action, thus creating the 503 A's and B's, I think, or at least creating a lot of the rules that we exist today. They did not reinstate the limitations on advertising, but in the process, they left this giant hole which has existed today, I think mostly because they didn't see it would be a problem. They'd gone a full decade without this being a problem. They think this was an answer and solution of a problem that doesn't exist. Let's not worry it. Let's leave it the way it is until GLP-1s came on the scene. And so a lot of what people are asking in all of that background is how on earth did we arrive at the present situation? And it is basically you got to turn to that Supreme Court case back in 2002. And then you had to see GLP-1s arrive on the scene. I would love to get your thought on that. But it does suggest that Congress wants to come up with some solution that mediates this tension between compounders and pharma. I think there likely will be a legislative solution, a different one now that they've seen it. But legislation takes time. I've been on the record, both on Twitter and within the Discord, saying typically, and this is the fastest you could expect, you might see some legislation introduced this year, maybe. It wouldn't see action most likely at the earliest until the end of next year after the election as part of one of these big omnibus bills that get passed after elections just before Christmas. And then if there is any regulatory piece to that where FDA has got to roll out some regulations, you can tack on at least a year after that. So at the earliest, you wouldn't see a legislative response. If there's no regulatory requirements, we're talking 2027. If there is a regulatory piece of it, we're talking another 6-12 months at least after that. So that's my take on the congressional piece of it. We'd love to, and since I did reference a Supreme Court decision, there's some legal aspects there. Any quibbles, pushback, thoughts on anything I just said?
Yeah, so I think about things from the perspective of a patent lawyer. And I think in terms of timing, this is not the first time where branded pharma has been in conflict with other, technology or other competitors in terms of congressional action. And what I'm thinking about, and this I think might be relevant on a number of fronts, is when Obama was elected president, right? And there was a big push. He had a lot of support from the big technology companies, the Googles, the Facebooks, those types of folks. And what was happening in the patent universe at the time, and really through the, let's say 2004 to 2008 time period, was all the patents that had been issued to startup companies during the dot-com boom were, the companies were going bust. The patents were hitting the open market, were being purchased out of bankruptcy for pennies, and were being used to sue, big tech companies, right? So, websites, your website has a shopping cart, let's go after you, right? Well, all those cases. And the big tech companies were fed up with it. And it was almost a perfect storm. Obama is elected. He immediately hands over control of the patent office to his big tech friends, right? Michelle Lee, who was from Google, becomes commissioner of patents. And everybody knows that we're heading into an era where patents are going to be diluted in terms of value. And all that culminates in 2011 with the passage of the America Invents Act, which is, it was really the Patent Destruction Act, but they gave it a nice name, America Invents Act. And that actually was the statute that introduced this IPR system that we've mentioned, right? Which is the ability of people to run to the patent office after they get sued to challenge a patent. And even to get, and they made it so broad that any third party could challenge anybody's patents for whatever reason that they wanted. And, guess what? Big Pharma was against that, because Big Pharma, they have a lot of value in their patents, right? You could have multi-billion-dollar drug franchises protected by 2, 3, or 4 patents. And if I introduce a new legal scheme where anybody, including short sellers, and I don't know if you guys were around when Kyle Bass, had a short selling strategy around challenging pharma patents. Didn't really go that far, but it was, a worthwhile effort. That all ended up becoming part of the story. So, Big Pharma has been on the losing end. As powerful as their lobby is, they've been on the losing end of some of these types of disputes. Now, whether or not there's legislation, I think the history of the American Invents Act tells us a few things. One is Big Pharma doesn't always win. Number two is even under the perfect storm of favorable political wins, legislation takes time to implement, and I think here, it's going to be interesting to see what kind of coalition, whether it's patient rights groups, whether it's, kind of the anti-patent crowd, right? What kind of coalition could arise against branded pharma if branded pharma wants to undercut, kind of compounding in general in a broad way, or even go after GLP-1s. I could see, insurers having a say, especially if they're, saving money at some point by, dealing with obesity by making people take the drugs instead of paying for diabetes, the rest of their lives. There's a lot of different ways that this can go. When we think about congressional action, that's not a prediction game that I want to get into, but I think there are precedents out there that suggest it's not always smooth sailing for the branded drug companies, no matter how much they try.
That's a good answer. Jonathan, back to you to wrap it up, I guess.
Yeah. So I want to bring it home. I want to sort of offer a summary of what we've heard, which is that Gaston, please jump in at any point and just correct me if I'm off base here. But the takeaways are roughly as follows, which is that it is unlikely that Novo Nordisk will sue Hims. That if they do sue Hims, it's likelier to be on trademark or false advertising or patient safety grounds than on patent grounds, because it's just very risky to go down that road. That as the case is happening, if the case is brought against Hims,
sorry, phone ring.
All good. Yep. That as the case is happening, if the
it's
case
Novo. They want me to shut up.
Yeah, Novo. As the case is happening, that Hims very likely would not have to stop compounding for the duration of the suit, because to get a preliminary injunction, it's really quite involved. And that if the lawsuit does come to pass, your view is that Hims would have a pretty good shot of winning, or at least getting settlement terms that are pretty favorable. And then with regard to the laws governing all of this, that they're unlikely to change in the near future. I don't know that you gave a timeline as to like when they might actually change, if ever, but you said, let's not necessarily bet on Big Pharma, because the historical record shows that they have been ruled against from time to time. Is all of that square with what we've heard the last, 78 minutes?
Yeah, and I'll just conclude with 2 points that I think are important to keep in mind. One is, even though a case against Hims by Novo is unlikely, I do think we are in a little bit of a period where the likelihood of a case getting filed is higher, and that has less to do with the merits and more to do with potential fallout from the dissolution, right? I don't want to give the impression that there's no risk whatsoever. In fact, we're probably in a period of heightened risk. And then the other thing that I just remember, caution everybody to remember, is that developments on the patent side in the generic lawsuits need to be monitored, because that might change whether or not Novo is willing to put their patents at work against Hims. And definitely the success or failure of Lilly in the Empower and Strive cases, I think, is also going to be indicative of both Novo and Hims' valuation or evaluation of the likelihood of success of their legal claims or defenses. So, as with everything, we operate in a very complicated legal environment where there's a lot of inputs that could have influence things. But given what we've said, given those two caveats, I think you've properly encapsulated what we said, and it's going to be an interesting story to watch no matter what happens.
Great. And so my takeaway then is that with each day that passes, the likelihood that Novo sues Hims drops.
Potentially. Yeah. Unless Hims starts doing something different, right? Based on what they're doing right now. But
True.
There's always going to be, if Hims, pivots or starts advertising in a different way, I think that resets the clock. And that's something that we have to keep an eye on.
And I guess final question, and maybe this is in what you just said, but if Novo were going to sue Hims, why hasn't it happened already? Why didn't it happen when they issued the scathing PR? Why didn't it happen the day after? Why didn't it happen this morning? What are they waiting on?
They might be waiting on want to see how Hims is going to do in the post FDA shortage, right? You're not going to, like I said, there's always good arguments. Like we started this discussion, right? There's always good arguments not to sue. And if you add to those kind of generic arguments why lawsuits are not always the best approach, a real question of, is somebody even worth suing? Then that I think can be very, important to evaluate. And Novo doesn't lose much by waiting to see just how successful Hims is going to be in this post FDA shortage. They could bring the case whenever they want. Yeah.
Well, we're at close to 82 minutes. I think this may be our longest episode of all time. If not, it's definitely top 2 or top 3. I have to say, extremely substantive all the way through, and just wanted to thank you, Gaston, for taking the time today. And this will be watched by thousands of people around the world. So, thank you for taking the time. This has been Hims House, episode 37. Thanks for coming on.
Thank you, guys. Great conversation, and look forward to next steps.